We've now published our scoping consultation paper on firearms law. We make a series of provisional proposals designed to fix some of the most pressing problems with firearms legislation. The proposals seek to maximise public protection against the misuse of firearms, whilst providing much needed clarity for the licensed firearms users. In our 12th programme of law reform, we were invited by the Home Office to consider the range of problems posed by the current firearms legislation. Stakeholders suggested that there are a number of significant problems. First, there is the lack of definition. Some of the most important terms in the legislation remain undefined. For example, for something to be classified in law as a firearm, it must be a lethal barrelled weapon, but the law does not specify what lethal means or how lethality should be determined. This poses problems because police and prosecutors cannot easily discover whether a particular weapon is classified as a firearm. We make provisional proposals that will resolve the practical problems. We suggest that the term lethal should be defined by reference to a scientific threshold based on kinetic energy. We're consulting on what the precise threshold should be. Secondly, certain ambiguities in the current law are being exploited by criminals. For example, it's lawful to possess without a certificate a firearm which is antique and which is held as a curiosity or an ornament. Unfortunately, the legislation fails to define antique. Whilst this provision is primarily relied upon by legitimate collectors, there is evidence to suggest that it's being exploited by criminals. The current state of the law presents problems for legitimate antique collectors and enthusiasts because they cannot be confident that the firearm they possess will be classified as an antique. We make some provisional proposals as to how antique might be defined more clearly and more effectively in the legislation. A third problem with the existing state of the law is that it has failed to keep pace with modern technology. To take just one example, the legislation that tackles the problem of imitation firearms that can be converted into live firing ones originates from 1982. Part of the test relates to whether the tools needed to convert a weapon are ones that are in common use carrying out DIY in the home. If the weapon can only be converted by more specialist tools, it's not caught. Nowadays, specialist tools such as diamond tip drills are readily available, particularly via the internet. To bring the legislation up to date, we provisionally propose that focus should be on the ready availability of the requisite tools or equipment, rather than on whether they are in common use by people carrying out maintenance on their homes. A more overarching concern with the legislation relates to incoherence and complexity. Numerous problems arise because there are 34 separate acts dealing with firearms, with some dating back to the mid-19th century. The legislation has steadily accumulated over the years, with so many different pieces of legislation enacted at different times with different purposes. There are bound to be inconsistencies and clashes of policy. A great many of the problems are attributable to complexity and incoherence that have been brought to our attention in this first phase of the project. These have led us to conclude that the time has now come for a more fundamental overhaul of firearms legislation. We ask consultees whether they agree that a review of all the firearms legislation is now desirable. The consultation runs until September the 21st, and we would welcome responses to the email address on the website.